The usual hill we fight on in a DWI case is whether my client was legally intoxicated. In this case, based on the video and blood results, that wasn't going to be the issue. I had a 25-year commercial truck driver stopped for supposedly driving all over the road. After performing horribly on field sobriety tests, he submitted to a blood sample showing a BAC of 0.217, nearly 3 times the legal limit. The usual hill we fight on in a DWI case is whether my client was legally intoxicated. In this case, based on the video and blood results, that wasn't going to be the issue. We staked our entire defense strategy on the ground that the officer's initial detention was illegal. And due to my client's Fourth Amendment rights being violated, all the subsequent evidence would need to be suppressed as the fruit of the poisonous tree. In this case, we had an anonymous tipster call in to report that my client was all over the road and must be intoxicated. However, he never gave his name and number. When cops showed up behind them, my client briefly left his lane of travel by a tire width twice, but with no cars around him. We asked for a motion to suppress all the evidence based on an illegal traffic stop. We successfully argued that the anonymous tip could not be relied upon to justify the stop, and what the officer saw wasn't enough to warrant a traffic stop. In the end, my client, with a slam dunk case for the state, ended up with a complete dismissal of his case, motion to suppress granted, all the evidence excluded. He saved his CDL and his livelihood.